Morning, everybody. Thank you for joining Emma and I on today's seminar, which is about redundancy and restructuring. My name is Fiona Powell and I'm a Managing Associate in the employment team at Freeths, and Emma Batten, who will be talking a little bit later on, is also a Managing Associate in the employment team. So we both have quite a lot of experience in terms of advising employers on day-to-day employment issues, and obviously with the current climate as it is, the pandemic, the effect it's had economically, a lot of questions are coming to us at the minute about redundancies and restructuring, so that's obviously why we've covered this topic today. Do be aware that your cameras and your microphones, we can't see you, your microphones are on mute, so if you do want to ask us any questions during the session, please do use the question and answer function, and we are going to try and get through as many questions as possible. We want to make it interactive and tailor it to you as much as we can do. We've had a lot of questions that have been sent in beforehand, which we'll be going through, so thank you to everybody who sent those in, and we've had a great response in terms of this seminar and in terms of attendees, which I think just shows that it is a topic that's on lots of people's minds. And I think in the press at the minute on a daily basis we're seeing obviously a lot of big names, Marks and Spencer this week, going through this process. So we want to talk you through that process. I'm just going to put the agenda on the screen, which is on the next slide, and just running through that agenda, we're going to take you through a case study, because redundancy, it can be quite a complex area. It covers both collective consultation and election of employee representatives and individual, so it can be one of those tricky areas to navigate yourself through. So we thought by putting it into a case study, make it a bit more practical and bring it to life. Of course, we've only got about, we're aiming to talk for about 50 minutes today, so limited in time in terms of such a vast subject, because you could spend several hours talking about it, but we want to cover all the key things and highlight those key areas for you. So we'll be looking at the preliminary considerations when you're going through a redundancy process. I think your planning stages are really important. Firstly, to identify whether it is a genuine redundancy situation, and then secondly, to look at your timelines and your planning as well. We'll then look at selection and pooling pitfalls. Then Emma's going to come on to collective and individual consultations. There's obviously quite a lot of COVID-19 specific issues that have arisen, which employers are having to navigate as well. And then we're going to come on to the question and answer. And the question and answer is going to be roughly about half the session. So we'll crack on. So if we just turn to the first slide, and what I should mention as well is that, of course, use the Q&A function to ask us any questions as we go along. Because we're limited in time, if we don't get to answer your question, Emma and I will individually respond to them. So please do send your questions in, and if you think of anything afterwards, Emma and my details are on the back slide of the presentation today, so you'll have our emails and you can just drop us a line. So the case study that we've set out for you is a company, a UK-based pre-packed sandwich manufacturer employing just over 260 staff in total. So obviously the number of staff is something to look out for. 3 sites, again, something to be wary of in terms of we've got 3 sites here: Bristol, London and Oxford. The new site in Oxford opened earlier this year, but due to the COVID pandemic, 75% of employees have been placed on furlough as part of the government's coronavirus job retention scheme. And they have noticed their sales figures have been significantly adversely affected during the initial outbreak of COVID-19. And it's anticipated that the company's figures will continue to be affected for at least the next 12 to 18 months. So a scenario that I'm sure a few businesses are currently in. If we turn on to the next slide, we've set out an organogram for you in terms of this company. I think, again, a similar process that you would be going through if you were looking at your business and any sort of reorganisation or restructuring. So you can see in this business we've got one overarching managing director, and then at each of the 3 sites we've got a managing branch director for London, Bristol and Oxford. You've then got operations managers, and you've then got kitchen assistants and warehouse food service drivers. So what's the first question that we need to look at? And if we come on to the next slide, the first consideration is, of course, whether this is a genuine redundancy situation. So in order to improve their financial position, the company is looking to restructure the business, and they're looking to do this by closing the Oxford site, having just one role of managing branch director across the remaining 2 sites, and then cutting the current 24-hour operation to a 12-hour 6 till 6 p.m. shift instead. And that will change for a third of the employees who currently work 6 p.m. till 6 a.m. So first question is it a genuine redundancy situation? And this is where you need to turn your mind to the legislation, which is contained within section 1391 of the Employment Rights Act, which sets out 3 situations which amount to a redundancy. Firstly, a business closure. I think that's relatively straightforward, where it's a full-on business closure. Next, you might have a workplace closure, where there's a closure of one of several sites or a relocation of a site. And then lastly, the diminished requirements of the business for employees to do work of a particular kind. So I think if you look at those 3 situations, clearly closing the Oxford site entirely is going to satisfy that definition of redundancy. Secondly, we've then got one role of managing branch director across the remaining 2 sites. And you recall from the organogram, there were 3 managing branch directors. So clearly, again, there is a diminished requirement of the business for employees to do work of a particular kind. And then lastly, we've got this change in shift patterns. And, you know, that's something that often creeps up in terms of if there is that sort of change, is that a redundancy situation or is it a change in terms and conditions? Well, there is an authority on this, a case, Johnson and Nottinghamshire Combined Police Authority, and they confirmed that where the employer changed from core hours to shift work, that didn't constitute a change in the kind of work, so it didn't amount to a redundancy situation. So in that kind of situation, if you changed the terms and conditions in that way, you would consult with the employees. If the employees don't agree to that change, and you took them through a dismissal and re-engagement process and they resigned and claimed constructive dismissal, and a redundancy payment, they wouldn't be entitled to the redundancy payment. So that's just something to be aware of. So first port of call, determine whether whatever you're proposing is in fact a genuine redundancy situation. And then if we go on to our next slide, you've then got to look at, you know, the numbers that you're looking at in terms of your proposals. And remember, at this stage, it's very much, there's no definite decision that's been made. It is very much a proposal that we've got in our minds about how we're looking at reorganising the business. So how many redundancies are being proposed? Look at that first of all, and that's important in terms of your process and particularly your timeline, and whether you need to collectively consult or collectively consult and individually consult, or just individually consult. So you'll either be doing both processes or just the individual consultation, and Emma's going to talk about that in more detail shortly. You've also got to look at your selection criteria and your pools. Particularly in this situation, we've got a pool of the branch managing directors. And just to recap on some of those basics about pools, you've got to, remember there's no fixed, rules about how you determine the pool. It is ultimately for the employer to determine, and the tribunal will want to see that the employer has turned their mind to that issue, and that essentially that pool is within the range of reasonable responses. The starting point is obviously to look at where there is a diminished requirement for work. You then look at what work is similar, if there's any positions which are interchangeable. As I've said, look at whether the employer has genuinely turned their mind to the issue of pools. And then as part of the consultation process, you will of course consult with the employees about the pools that you have determined, and you will, if any issues are raised, then you can consult on that. So you should know if there's any issue during that consultation process. So that's your pools. You've then got your selection criteria. And remember, with your selection criteria, it should be as objective as possible and as measurable if you can possibly do so. So that kind of criteria, such as performance, length of service, attendance record, disciplinary records, they're all things that you can measure via appraisals, HR records, performance records, etc. And then as an employer, you will draw up a matrix, attach a weighting to demonstrate the relative importance of the criteria, and score the person appropriately. So in the situation that we've got in the case study, everybody in the Oxford site is going, so that's pretty straightforward because there is a site closure. In terms of the reduction in the managing branch directors, you've got to look at the pool there, and I think the pool is quite easily defined in this situation, but depending upon your business, it may be that roles are labelled differently, but in fact they're interchangeable. So that's might be where you're looking at a wider pool. And I think that's the pitfall with pools, is that employers will want to focus on a more narrow pool, employees want to widen the pool. But remember, the wider the pool, then that can be an issue in terms of it's more onerous in terms of that consultation obligation, and also you're affecting a wider group of people, which can be damaging in terms of productivity and morale. So we've talked about the pool, and then of course, as I've talked about, you then have to determine the correct or the type of selection criteria you want to use to score, and then apply that to determine who you're proposing to put at risk. And of course, you've got to be mindful during this process about discrimination issues, and we don't want to use any criteria which could be discriminatory in any way. One issue that we're often asked is, can I make an employee who is pregnant or who is on maternity leave redundant? And the answer is yes, it is possible to do that. However, the reason for the redundancy must be wholly separate from the pregnancy or maternity, and you have to follow a fair process. And of course, do remember that with employees who are off on maternity leave, they should be treated more favourably in the redundancy process. And if there is the option of suitable alternative work, they should be offered that in priority to other employees who are at risk. So on that basis, I'll just hand over to Emma, who's going to cover collective consultation.
Hi everybody. Yes, I'm going to talk through the obligations in respect of collective and individual consultation. So I suppose the first question is, what is the difference between collective and individual consultation? Well, collective consultation involves consulting with employee representatives about various matters that arise from the proposed changes, including ways of avoiding proposed redundancies, reducing the potential number of redundancies, and mitigating the consequences for the employees affected. And then following a collective consultation process, you would then consult on an individual basis with those employees that are affected to go through the usual individual redundancy consultation process. So as you'll note from the slides we have on the screen there, the obligation to collectively consult essentially kicks in or is triggered when an employer is proposing to make 20 or more employees redundant at one establishment within a period of 90 days or less. So in respect of our case study that we're looking at this morning, this threshold has quite clearly been met. Obviously, we are looking at a site closure of the Oxford site, which employs 62 redundancies, and therefore that 20 employee threshold has been met. So what does it mean if the collective consultation obligations are triggered? Well, the obligation to collectively consult is set out in a piece of legislation called the Trade Union and Labour Relations Consolidation Act, If you ever have any trouble sleeping, I'd recommend reading it before bed. It's also referred to as TOLCRA, and that operates in effect as a moratorium on any proposed dismissals, whereby the dismissals can't take effect for a minimum period once the consultation has started. Now, in terms of the importance of collective consultation, the maximum sanction for breaching the obligations under TOLCRA is a protective award of up to 90 days gross actual pay, so it's not capped, per affected employee. So if you're looking at figures like we have, for example, in our case study, if we were to get that hugely wrong, you would be looking at up to 90 days pay for everybody who's affected, so the 62 employees, which, as you can see, would potentially add up to a substantial sum of money. So it is a process that is important to get right, and important that there is some thought and planning that has gone into the process before it starts. So, as well as having minimum consultation periods, so in respect of collective consultation, that's 30 days if there are between 20 and 99 employees proposed to be made redundant, or it's 45 days if it's 100 plus employees. The obligation to collectively consult will either be with the trade union representatives, if there is one, if there's a recognised trade union at your site, or employee representatives who have been elected to undertake that process. Now, there are quite prescriptive rules and procedures that need to be followed in terms of getting to a place where you have employee representatives in place, and we unfortunately don't have time to go through all of that today, but if you do have any questions about that process, then let us know and we can assist with that. So what we thought it would be helpful to do today is to kind of just go through some of the common pitfalls that we see, that we've seen across the years with businesses that are undertaking the process, and to just highlight some key areas that are sometimes overlooked or forgotten, just so that they are on your radar if this is something that you need to be advising your business on. So first of all, alongside the obligation to collectively consult, if you reach the threshold for having to undertake that process, you will also have to notify the Secretary of State of the proposals to make the employees redundant within a 90-day period. And that is undertaken via an HR1 form, which some of you may have undertaken previously, but it's essentially a form which confirms the proposed numbers that you're looking at and the kind of time frames. And it's essentially so that local authorities can plan in terms of kind of job assistance that will be needed if there's large-scale redundancies proposed in the kind of local area. And it's actually a criminal offence not to provide that information. So again, sometimes if you're kind of knee-deep in the consultation process, it can be overlooked, but it is important that that information is provided at the right time. And again, the timeframes for providing that information is the same as the minimum consultation period. So it's kind of 30 days if there are 20 to 99 employees, or 45 days before the first dismissal if there are 100 plus employees. So that's just something to bear in mind. The next pitfall or thing we wanted to kind of highlight was the specific written information that needs to be provided as a minimum as part of the collective consultation process. And again, this information would either be provided to the employee representatives or to the trade union, depending on who you were consulting with. And that information is set out in section 1884 of the TOLCRA legislation, and it includes the reasons for the proposed redundancies, the number and descriptions of employees whom it's proposed to be made, proposed to dismiss as redundant, the total number of employees employed by the employer at the establishment in question, the method of selection, the method of carrying out the dismissals, as well as the method of calculating any redundancy payments if anything is being paid over and above the statutory redundancy scheme, as well as any suitable information about the business's use of agency workers. So again, it's just making sure that you are kind of ticking off that information as being provided to the relevant individuals as part of the process. The consultation and the purpose of the collective consultation is undertaken as a means of avoiding redundancies, reducing the numbers and mitigating the consequences to the employees. And it's also needs to be undertaken with a view to reaching agreement. Now, obviously, we all live in the real world. Agreement is not always going to be reached, but it's really important that this isn't taken as simply a tick box exercise. You are listening to the proposals that are being made by the representatives, and you are considering and responding to those accordingly. And the key really is to make sure that you are going into the process with an open mind. So not having any kind of predetermined or predefined answer. Being open to consideration and persuasion that there may be a better or fairer way to approach this, being open to change and potentially extending the process if further time is needed to consider the proposals that are being put forward, and just making sure that the consultation takes place before any final decisions are made. And one kind of key point here is to make sure that you are being careful in terms of correspondence between perhaps HR and senior management or director boards about numbers and decisions. It all needs to be subject to consultation, and if for any reason you do find yourself on the end of a claim for unfair dismissal or failure to inform and consult, if there are any emails back and forth about which suggests that there's been a kind of predetermined decision and there is a finality in that decision before the consultation has happened, that would all be disclosable as part of any tribunal process. So just be mindful of that when you're corresponding internally about the process.
Emma, just to add on that as well, I suppose, you know, we have all seen an increase in employees making DSARs, so data subject access requests, and if their name, obviously there is an obligation in that instance to provide any information from which they can be identified. So if their name was on it, they might be able to get it earlier. You know, in terms of timelines, any sort of information like that, do be careful about your wording, and that it is very much proposal, nothing is set in stone, because of the increase in employees making data subject access requests. I know we've certainly seen lots of employees doing that, and employers getting themselves in difficult positions because something has been put in an email and then it's had to be disclosed. Of course, just also remember that if you are seeking advice from a solicitor on a redundancy process, if they're kind of CC'd into any correspondence, then it would be covered by privilege, and so that wouldn't be disclosable. So just to point that out as well.
Yeah, no, that's a really good point, because we are seeing a lot of DSARs at the moment, and I think it's often seen as a bit of a fishing exercise, but obviously if that fishing exercise turns something up, then it could mean difficulties down the line with tribunal cases. So yeah, absolutely, just be mindful of that. Another question that we are quite often asked is whether notice of termination can be issued during the minimum collective consultation timeframes. So within that 30-day or 45-day period, whether the notice of dismissal can be issued. And I suppose in short, the short answer is, in theory, yes, it can. The requirement is for the minimum period to elapse between the start of the consultation and the date the first dismissal takes effect. So as long as somebody isn't being dismissed within that 30 or 45-day period, then you are able to issue that notice of termination. But I would advise you strongly to exercise caution in respect of that, because I think the danger of issuing notices of termination during the consultation period is that that there could be an argument that the employer hasn't allowed the full consultation period to run its course, and obviously issuing notice of termination does indicate that there is a degree of finality and a decision has been reached, certainly in respect of those employees who have been issued with that notice. So I think you just need to be very cautious of, if there are still ongoing discussions, then letting those discussions take their course and making sure you are as far down the road as you possibly can be in terms of reaching agreement, which is obviously the key for the collective consultation process. Sometimes individual redundancy consultation process is also overlooked. I think businesses can get very kind of bogged down with making sure that they are doing everything by the book in terms of the collective side of things, that sometimes they then forget that actually for there to be a fair dismissal and for a business to be able to show that there has been a fair process followed, there does need to be a consultation with the individuals as well as the kind of collective side of it. Otherwise, there is a risk there of being exposed to potential unfair dismissal claims. And then finally, I suppose the last kind of point I wanted to highlight, and again, it's something that we're often asked questions on, is whether a business can use redundancy as a means of removing a poorly performing employee from the business. And I suppose there are a couple of sides to this. Firstly, the first point to note is there needs to be a genuine redundancy situation. So if there is not, then and you're not falling within any of the three definitions of redundancy that Fiona spoke about earlier, then there's a potential issue there and a potential risk of a claim. Secondly, if there is a redundancy situation, then you need to obviously be aware that it's going to come at cost. So there may be a redundancy payment that will need to be made, which if you have an enhanced scheme, that may be relatively significant if you've got a long-serving employee. But I suppose the flip side of that is you will be saving the time of undergoing a performance management process, which if any of you have undertaken that previously, you'll be aware that that can take a good couple of months to get to the stage where if there's no improvement, that you can kind of safely, as far as you can, dismiss. So it's about kind of weighing up the cost of that, I suppose. And again, going back to whether there is if there is a genuine redundancy situation, if there isn't, and you do still need to fill the role, i.e. it does still exist, then you just need to have a think about how you're going to manage that in the future in terms of if somebody is put into that role to replace the dismissed individual, then you could potentially have a claim on your hands for there not being a genuine redundancy situation. If you do ultimately go through that process and you do kind of use redundancy as a means of removing a poorly performing employee, you just need to be making sure that the focus is on the process of the redundancy as opposed to their poor performance. So you don't want to be saying as part of the process you are being made redundant because you are a poor performer. Obviously they may be scored as part of a selection process, and one of those scores may be performance, which if that's supported by appraisals and they receive a low score in respect of that, then that is justified. But the focus doesn't need to be on the fact that they are a poor performer. Once they are the lower scoring staff and they are placed at risk of redundancy, then it's much more about discussing the fact that their role is at risk of redundancy. So just moving on to specific kind of COVID issues, I'm sure most, if not all, of your businesses will have been affected in some way or other by the pandemic, whether it be employees that are furloughed, people working from home, employee shielding, so not currently working. There's lots of ways that at the moment businesses are affected by COVID, and that's not even considering the kind of financial and commercial implications. So in relation to redundancies and specific COVID issues, the first thing you may want to be looking at when you're considering whether you're making redundancies is those employees that are on furlough leave. And obviously in our case study, there's a significant number of employees that are currently on furlough. So the question is, how do we kind of make contact with them? How do we start the consultation process? Well, there needs to, firstly, we need to be making sure that we've got up-to-date information for the employees that are currently on furlough leave, and there needs to be a process whereby they can be contacted to be advised that they need to check their emails if there is important correspondence that's gone out in respect of a redundancy process that's starting, for example. Or if you are sending that correspondence out by letter, it may be from a kind of good ER perspective to ring round employees who are on furlough before that letter lands, to just advise them the fact that that letter is going to be received, because I think the time spent doing that will probably be more beneficial than dealing with the deluge of queries that you will get once it lands on their doorstep. So I think it's probably sensible to look at that. And then related to the first point, you then need to look at how physically the redundancy process is going to happen. And given that there are a lot of employees that are currently working from home, or perhaps are shielding and don't feel comfortable having a physical meeting, it may be that you're looking to undertake consultation via either the phone or by video call. So just making sure that you've got that infrastructure in place to be able to do that. And just need to obviously highlight that if you are undertaking individual consultation, the employee has the right to be accompanied by an employee or a trade union representative. So again, just making sure that you're able to accommodate that, and that they are able to dial in or be joined to the video conference. So just making sure that you are allowing that. So in respect of particular considerations for those employees that are currently on furlough, that are being made redundant, again, I think a lot of businesses are now turning their minds to whether they need to undertake a restructure and reduce headcount, because obviously the furlough scheme and the job retention scheme is changing, and the government contributions are reducing, so employers are having to make more of a contribution from the 1st of August. So if you have an employee on furlough, then the company can still claim their salary costs via the job retention scheme. So if they are made redundant and they are placed on furlough leave during their notice period, then company A, in our case study, would be able to claim their salary costs for that period, obviously up to the prescribed limits and in line with the various contributions that are coming in and changing over the next couple of months. Redundancy pay can't be claimed, so that is something that the business would have to foot the bill for themselves. And one question we've had from a couple of businesses is about whether employees have a good argument to say that they should remain on furlough to see if things change, obviously when until the furlough scheme is cut at the end of October. And I think that's probably a bit of a tenuous argument, particularly in line with the changes that are happening, kind of coming up, where businesses are having to make more of a contribution to the salary costs. It's not simply a case that they have no contribution anymore and the employee can sit there until the end of October and we can then consider things. I think if there is a genuine business case for having to make cost-cutting measures at this time, then I can't see employee having a successful argument that they should remain on furlough leave until the end of October. I think it's down to the business really, and tribunals very rarely go behind a kind of business decision that's been reached, because obviously all companies are different. So we're going to move on to the Q&A session now. Thank you for all of the questions we've had in. We've had some really good questions. Likewise, if you have any more that you want to ask kind of during the session, then we will try and get round to them as well. Otherwise, we will cover them off separately with you. So Fiona, I'll pass you over to you to deal with the first couple of questions we've had.
Yeah, so the first question we had was, at what point can you issue notice if after several meetings the consultation process has reached a stalemate? So what's reasonable? Now, we've covered this as part of the seminar, so you can issue notice of redundancy during the minimum consultation period, although the dismissal obviously can't take effect until the minimum period has lapsed. So once that notice of termination of employment has been given, the employer is effectively saying that the consultation process is at an end, at least in respect of those dismissed employees. And, you know, going back to the legislation and what it says, that collective consultation process anyway is with a view to reaching an agreement or exhausting the possibility of agreement. So if at that stage you feel that, I'm talking specifically about collective consultation now, that you know you have exhausted that, I think providing that you're documenting that in the minutes, then I think you know you could potentially then conclude that process and then move on to the individual. Specifically, obviously, you wouldn't issue notice until you're in the individual consultation process stage. But in terms of that individual consultation, again, I think as providing you have gone through the process and you know there is this two-way consultation, it's about listening to the employee, obviously talking about the reasons for the redundancies, what are the alternatives, what are the ways to avoid, talking about their score, enabling them to challenge it. If through that process we have, you know, exhausted, you know, proceeding any further, we've answered all the questions, it may be that we get to that stage where yes, we feel that we can't progress a consultation anymore, and we then have to issue that, you know, our notice to dismiss. So yes, you can do it, but just make sure that you have gone through that process, that you have exhausted, bear in mind what the consultation process is about. The next question we had was about furloughed employees, and obviously somebody whose pay varies. And this question says, which 12 weeks do you use to calculate the average weekly pay? And is this applicable to redundancy pay and notice pay? So what we would suggest is that you use the 12 weeks prior to the furlough period. That would be applicable to redundancy and notice, but remember with your redundancy, a week's pay is capped at currently 538 a week. So just do bear that in mind. We've had another question in about a company that's looking at about 7 redundancies currently, and are wanting to know what to do if at a later stage they make more redundancies that brings them over the 20 mark, and at what point they need to submit the HR1 form. So remember, as Emma ran through, that under the legislation you have to notify the Secretary of State on the form HR1 where you're proposing to dismiss as redundant 20 or more employees at one establishment within a 90-day period. Now, if it's between 20 and 99 proposed redundancies within a 90-day period, you have to provide that notification to the Secretary of State at least 30 days before the first dismissal takes effect. If it's over 100 proposed dismissals, the time frame is slightly different, it's 45. So it's very much going to depend, if you are staggering dismissals, it depends whether that next tranche that you do falls within the 90-day period. If it does, then that HR1 should be submitted either within 30 or 45 days before the first dismissal takes effect. Now, this question hasn't asked it, but some of you might also be thinking, well, also, does that trigger the duty to collectively consult as well? And what should we do in that instance? And there has been one first instance decision on this, but in that particular case, notice of dismissal had been issued, and they effectively argued successfully that you know, you have to look at what's in the mind of the employer when they do the first batch, and did they have the second batch in mind when consulting on the first. But as I say, it is a first instance decision. It hasn't been tested by the higher courts. I suppose the alternatives for you, if you are doing it in batches, is to look at whether you do a second batch after the 90-day periods, or you take a view, well, I'm going to consult on it so that I protect myself, because as Emma's pointed out, if we're not following our collective consultation obligations, there is that risk of a protective award. There are special rules that apply. If you have collectively consulted, say you make 30 people redundant, and then a few months down the line you're then going to make another 10, do you have to collectively well, it wouldn't. What do you then have to do with in relation to those 10? And you can individually consult in relation to those. If you hadn't started the collective consultation process, I think you would consult on all 40. It's, you know, it's quite a complex area, so I think, you know, any kind of staggering of dismissals, there is an element of risk there. You could be challenged by employee reps saying, well, have you done this as an avoidance tactic? You don't want, obviously, the risk of a protective award. So it's one of those areas where I'd most probably suggest getting some advice in relation to that. Had a question, can an employer rely on their anticipation of a diminished requirement when they can't actually predict their market going forward? I think that's a really good question, because I think a lot of businesses are in this situation at the moment. You know, I suppose firstly, remember that you consult when it's a proposal, not necessarily, you know, we've made that decision. But you've got to really go back to the definition of redundancy, i.e. that business closure, that workplace closure, or if there's a diminished requirement for the business of work of a particular kind. And if you're anticipating it, but you can't actually predict it, then, you know, if people are working at full capacity at the minute, and there's nothing to suggest that that is going to change, nothing significant, i.e. a customer confirming that they are going to cancel their contract, then is that a genuine redundancy situation? And certainly there might be a question mark over that. And, you know, I would expect to see that the employees challenge you during the consultation process and say, well, hang on, is this really a genuine redundancy? There hasn't been a cancellation of the contract. We're still working at full capacity. So I think you just have to prepare yourself for that line of questioning. And certainly a tribunal, they don't look behind the employee's decision, providing it's reasonable. So, you know, I certainly think if you've got, there is an element of predicting, I know, with this, but I think there has to be something more than you'd want to see a drop off in work and or a real risk to the business flow that's coming in. I'll hand over to Emma just to cover off some of the latter questions that have come in.
Thanks, Fiona. So one of the other questions we had was if a member of staff whose role is declared redundant suggests an alternative to redundancy whereby they move to a vacant post that used to report to them with a reduction of pay of around 30%, would this be acceptable if the individual is happy? I understand that the individual is close to retirement and is happy to retain employment, albeit on lesser pay and reduced responsibility. Well, in short, yes. The purpose of the redundancy consultation is to look at ways in which redundancy can be avoided. If this role that had the 30% reduction in salary and obviously the reduction in seniority was being offered as a suitable alternative to redundancy as a means of avoiding redundancy, statutory redundancy payment if the individual refused it, unreasonably refused it, then you would be looking at whether it was genuinely suitable both on objective and subjective considerations. And obviously one issue there may be it's a significant reduction in salary and it's a significant reduction in seniority. But in this case, if you've got an employee who is happy to move into that role and they can do that role, then there's no issue, and it's a win-win really, and it's ultimately what a redundancy consultation is looking to achieve. So there's no issue with that at all. Obviously, you would need to make sure that new contracts and things were signed up so that they were clear in terms of understanding what their new salary would be, new job title, whether there was any change in benefits or anything like that. But assuming they're happy with that, then absolutely no issue there. The next question we've had is business needs to reduce its staffing numbers and there are varying lengths of service amongst all. Can a business legitimately dismiss those with less than 2 years service, but just pay them their statutory notice and then pool the remaining staff in a redundancy exercise? So this question seems to be around whether can we remove those employees that have less than 2 years service in the first instance and then go through a redundancy process with the remaining staff. Now, I'm assuming here that we are talking about numbers less than 20, because obviously if we were talking about more than 20, the collective consultation obligations would kick in, and any kind of failure to include those individuals within the numbers could result in them pursuing a claim for failure to collectively consult, which, as I've mentioned earlier, could be an expensive risk for the business. So I'm assuming that the numbers are less than 20 when I'm answering this. And I suppose the main thing to highlight is, although we could do this and there's no particular issue with it, I don't think, those employees do still have the right to bring claims for discrimination or whistleblowing. They don't need 2 years service to pursue those claims. So terminating their employment you could end up with claims for those issues if there were any complaints raised in respect of those issues. So you just need to be mindful of that. You also need to be mindful of those employees that are coming up to their 2 year service anniversary, because their statutory notice could be added on to their service, and if that took them over the 2 year period, they would then have the right not to be unfairly dismissed. So again, just make sure that the individuals we're talking about are some way away from their 2 year service. However, assuming there are none of those issues, then I think, and assuming all of the employees with less than 2 years service were treated the same, i.e. they were all dismissed, then as long as they were paid their notice, either they worked it or they were paid in lieu, and their accrued but untaken holiday, then the main risk here would be a claim for unfair dismissal, which is always the main risk in respect of individual consultation, is a claim in respect of unfair dismissal, and obviously these individuals wouldn't have that claim. So I think the risks would be relatively limited, obviously subject to the points that I highlighted. However, kind of from a practical perspective, I think it's probably worth just highlighting the fact that this may not be the best way to retain your talent. So although you may be saving some costs in terms of not having to pay redundancy payments to these individuals, you may be losing some of your highly performing staff simply by kind of putting an arbitrary line in the sand in terms of you guys are all going. So again, it's just about weighing up whether that is the route that your business wants to go down. And then another question we've had is around a team leader role no longer existing, and the business want to offer that employee a role within the team at a more junior level to keep their skills within the business. And this would mean that the employee would bump a member of the junior team out of their role and they would be made redundant. Can we do this? Well, this is a classic example of bumping. And whilst there's no legal obligation to bump a more senior employee into a more junior employee's role, in some circumstances, failure to consider it could render the dismissal unfair. So it's always worth kind of having in your mind whether that is something to look at. In this particular scenario, I think the first thing would be to discuss with the team leader the fact that there is going to be a proposal to place her role at risk of redundancy, and whether as part of the redundancy process, if following a scoring exercise, and she wasn't the lowest scorer within that group, would she be prepared to accept the kind of more junior role, which would presumably come with less pay and obviously less seniority? If she would be prepared, he or she would be prepared to accept that, then I think what I would recommend doing is placing the team leader and the junior employees into a wider pool, undertake that selection process, and it would be from that selection process that employee with the lowest score that would then be placed at risk of redundancy, and the senior employee would simply slot into the more junior role. Now, there's been various cases on this where very often the cases seem to centre around bumping having not been considered. So you get to the kind of termination stage and the employee says, well, actually, I wanted to do that role. I've got lots of years experience. I can easily do that role. So I think that's why it would probably be sensible to have that discussion at the outset, so everybody knows where they stand. The team leader understands that it's their role that's being placed at risk of redundancy. However, if their roles are relatively interchangeable, then you could widen the pool, and it would be the lowest scorer within that widened pool that would be placed at risk of redundancy. Now, I am conscious of time, so I think there are perhaps a couple more questions, but it may be that we... Sorry, Fiona.
There's one quite quick one we most probably can squeeze in. Can the cost of redundancy be used as a criteria for selection, i.e. if one individual costs 100k in terms of redundancy pay, but to select another would only cost 30? No, we don't normally use cost of redundancy, and I think that's something that you know, you as a business would have to consider prior to you know, your planning of that. Yes, some people might be more costly, but ultimately it's about retaining well, what your business needs going forward, retaining the right people for the work that's still required to be doing and what's been diminished. And ultimately, whilst some people might be more costly, if you no longer require that level of work, you are then making that cost saving going forward, aren't you? So, but no, we wouldn't. I've certainly not seen it been used as selection criteria. I don't know if your experience is different, Emma.
No, I agree, and I think, like Fiona said, I think it's probably one of those things that you would be looking at in terms of the planning of the process. So if there was a role that was redundant and it happened to be that it was that individual that undertook the very expensive role, then you wouldn't be looking to use the cost of redundancy as selection criteria. Yeah, I think, yeah, I've not got any further comments on that, I don't think. So I think that's all of the questions that we had. So thank you everybody for attending today. Hopefully you found it useful as a bit of a kind of whistle-stop tour in terms of a redundancy kind of seminar, webinar for you to be able to take away with you. I imagine that webinars are going to be the way things are happening for some time. So if there are any other topics or areas that you think would be beneficial, it can be outside of HR. So we've got health and safety specialists, we've got immigration specialists, or kind of anything else really. There's lots of disciplines at Freeths. What we were proposing to do is send around a kind of survey monkey after this session today. So if you are able to fill that in with your feedback, that would be great. And then comment on that if there's any other topics that you would find useful. Then hopefully we'll be able to incorporate them in our kind of webinar sessions that we're looking to kind of put forward in the next couple of months. And likewise, I think what we were planning to do today is send out a kind of checklist in terms of the redundancy process. So you've got a bit of an aid memoir if you are advising your business in respect of redundancies. So hopefully you'll find that useful, and we'll email that out hopefully later today.
just to add as well, I suppose if there's any feedback or comments in terms of not only topics that they find useful, but format in terms of Q&As and you know, even some sort of HR roundtable, anything that they would find useful, because I appreciate that at the minute there's lots going on for business, and I think not only being able to ask legal questions but share between businesses what other people are doing can sometimes be useful. So any feedback would be really useful to us.
Thank you.